A popular subject in the financial industry right now is SEC versus Ripple, and many believe that the Ripple case will pave the way for a further government regulation. The judge extended the discovery period by 60 days as requested by the Securities and Exchange Commission, causing concern in particular for the XRP community, which is counting down the days until they are all completed. Ripple has teamed up with RUTGERS Law School to advocate for reform in the Securities and Exchange Commission. According to Algorand 6 Clovers, a victory in the Ripple Fair Notice case may have a significant influence not just on Ripple and XRP, but on the whole crypto ecosystem as a whole, and could even partially upset the SEC. Digital assets constitute the hottest subject in the financial sector, and many view the Ripple case as a chance for further regulation in the field. Recently, the judge reversed the discovery for 60 days as sought by the Securities and Exchange Commission, with fear especially for the XRP community, who count the days before they've all finished. Here's the amended agenda. 96% of all SEC cases are settled before trial, 60% of them before trial, and 90% before trial. This truth is merely a pointer to what is to come. Anything can happen. Anything can happen. The Ripple community is ready to conclude the case, and attorney Jeremy HOGAN, one of his most popular members, shares his expectations. Mr. HOGAN indicated in May that if the incoming SEC chairman Gary Gensler retreated from the prosecution and works instead for more regulatory clarity, it would take place before the end of the month. That did not happen. Then President Gensler has embraced these processes and supports them for better or worse, even if we don't make it to June without resolution. If such is the case, I shall not forecast settlements until early September. If there is no solution and I go to summary judgment or trial, I anticipate, well, hell, I don't know. Do I appear like an intellectual reader? At the beginning of June, Mr. HOGAN described what an agreement might look like between the SEC and Ripple Labs, including possible harm to the XRP market. Now that the judge has reversed his discovery 60 days ago, the period for the litigation has shifted and Jeremy HOGAN modified his forecasts. Therefore, I go back to my earlier assumption that there would not be settlement until the end of the finding. Before then, could it settle? Yes, I don't believe it's probable. So any settlement may be at least after the factual finding, currently at the beginning of September, and still more probable after 16th October. What if both parties do not reach an agreement? In a summary judgment, I believe Judge TORRES will rule on two principal issues raised by the parties. Motions must be submitted within 30 days after the end of the discovery on 16th November, although answers to motions and submissions may in the future lead to an unknown summary judgment. I don't see a summary decision on the matter until early 2022, January perhaps, he concluded. The two primary concerns discussed above are Ripple's fair notice defense and whether XRP is a security or not. Regarding the fair notice defense, the SEC has recently cautioned the court that a Ripple triumph would negate the Howey test, the standard that has come under examination with the development of the digital asset class. Ripple has joined with RUTGERS Law School to fight for reform. A victory for Ripple in the fair notice case may have a significant impact not only on Ripple and XRP, but also on the whole crypto ecosystem, and it could even cause the SEC to temporarily halt its operations. A Ripple fair notice triumph may have a huge impact not only on Ripple and XRP, but also on the whole crypto ecosystem, and perhaps partially disrupt the SEC. As regards the nature of XRP, the SEC claims that because of its centralized nature, the asset is a security. On the other side, Ripple continued to propose new examples of usage for the ledger, an indication of utility. Regarding the asset's character, the SEC asserts that it is secure because it's controlled by a single entity. Ripple, on the other hand, has continued to suggest new instances of how to use this ledger, which is an indicator of its value. In March, in the form of the XRP admission, the judge released a bombshell that undermines the security rationale of the SEC. SEC Commissioner HESTER PEIRCE, widely known as the Crypto Mom, recently stated the SEC's objective when it submitted a complaint about a non-registered securities offering against an enterprise. If we consider that a crypto asset is a security, we argue that it is offered under an investment contract. It does not necessarily entail that the asset itself must be a security. It indicates it was offered as a security. In the meantime, a new rival led by former employees from PayPal and Ripple was born, Algorand 6 Clovers. It shows exactly how crucial it is for Ripple to conclude this legal chapter with the SEC. However, the regulator can utilize this sense of emergency as a lever. In terms of leverage, we examined the previous crypto accident and the role of market volatility leverage trading on margin trading with Ripple's XRP in mind. Final thoughts: SEC versus Ripple is the hot topic in the financial sector, and many view the Ripple case as a chance for further regulation. The judge reversed the discovery for 60 days as sought by the Securities and Exchange Commission, with fear especially for the XRP community, who count days before they've all finished. Ripple has joined with RUTGERS Law School to fight for reform in the SEC. A Ripple Fair Notice triumph may have a huge impact not only on Ripple and XRP, but also on the whole crypto ecosystem, and perhaps partially disrupt the SEC, says Algorand 6 Clovers.